Thank you. Welcome, everybody, to Wednesdays with Wightman Town Hall meeting. Today's topic is hot topics in school procurement and construction and contract law. So while we're waiting, if you can go ahead and open up your chat box and just maybe make a note in there to talk about or to just answer the question about what's the biggest procurement challenge or issue that you or your school district has faced during the COVID pandemic and the restrictions that have been imposed on school districts. Okay, well, my name is George Kakan, and I will be the Wednesdays with Wightman facilitator today. I am an architect with Wightman, and I'm also a recognized educational facility planner and a client representative. So the reason we've put the town halls together is to be able to share best practices for superintendents and administrators for school districts during this pandemic. Today's presentation will explore various restrictions and other challenges on school procurement. I'd like to introduce Dr. Tom Langdon. He's a part-time superintendent with Walkerville Schools, and he's also a mentor. He's an educational consultant for Wightman, past president of MASA, and I know that that conference is going on as we speak. And then our featured speaker today is Jeremy Motz. He's an attorney with Clark Hill and is a member of their Clark Hill's educational practice group. He counsels schools with a wide variety of legal issues, including procurement and real estate and other school operations. With that, Jeremy, I'd like to just turn it over to you to go ahead and get into your topic.
Yeah, I kept on going back to the meeting. So thank you everybody for attending. Thank you, George, for having me today. Pleasure to be here and excited to talk about some hot topics here in these procurement, construction, and contracting law and focus on these. And really as it relates to things that have come up that we've seen from clients during the pandemic and how school districts have had to transition away from some of their basic things that they've done and how they've changed the way in which they've operated to carry out the functions that are legally required by the school district, but at the same time accommodating the restrictions and other issues that this pandemic has caused us to deal with. And at the same time, some school districts are also looking at ways in which they could maybe change the way in which they're doing things and how they could do that going forward when some of the, hopefully the restrictions and other issues are alleviated and we can get back to how things were done before, and are there better things that we could do to make things more efficient? So we'll focus on some of those things as we talk today. So getting into our first slide here, we're focusing here on sort of the basic things, but these are some of the common misperceptions that we get questions on, and just because we've been in a pandemic hasn't caused these to go away. And so I always like to start with these to focus on some of them. So a lot of the questions that we've received is about single source in dealing with bidding and procurements. And if school districts are looking to secure some form of supply, material, and equipment that would be under 1274 of the school code, they only believe there to be one source, and does that alleviate their requirement to bid? And under the statutory requirements of 1274, which deal with supplies, materials, and equipment, and the construction bidding, which is 1267, neither of those contain a sole source or single source exception where you would then be not required to follow out the competitive bidding processes that are mandated by both of those statutes. So that always has been a common question during the pandemic because people are trying to get things done quickly, and procurement obviously adds a step which can add time and additional things to do. Another one that we always like to not forget about is a basic concept, is our emergency exception, and whether or not and how that applies when it deals with school building repairs. So this one comes a question a lot, and the main thing is this exception is under 1267 of the school code, which deals only with the construction aspects, the renovations, repair, alterations, or improvement of school buildings. And this exception only applies to the repair component of it. So if you are repairing a school building, you need to do that. You don't have to seek competitive bids in the process set forth of 1267, provided that it's an emergency repair. And so that's always a big question because the statute doesn't define what emergency is. And so our opinion has always been that it's the health, safety, welfare. So if you do not repair the school building, you're going to either have a detrimental effect on the building itself, where it's caused further damage to the building, or it's going to cause some health, safety, welfare issue to the students or occupants of the building. Obviously, during the pandemic, we've been a lot of virtual and remote learning. So obviously, the health, safety, welfare of students and occupants might not be the bigger thing right now, because there are some administrators and teachers in the building, which that would still apply there. But the emergency repair is one of those contexts, and it's always best to make sure you document that, maybe working with your architect or construction manager or construction professional to show that this needs to be done. An example is if the roof right now in the middle of winter is leaking, obviously water infiltration into your roof system with freezing and thawing is a bad thing. We would then not have to bid out if we had to put a whole new roof on or repair the roof, you know, and if maybe the whole new roof was the only way to repair it, that would be something that if it was an emergency, we could look at that. Other one that always comes up as example is a boiler. A boiler goes out in the middle of winter. Obviously that, even though it's a piece of equipment, it's a fixture. In doing all the work that replaces the boiler is seen as construction because they're more than just replacing a piece of equipment. And so that would be something you could repair and go on that way. So if you can go back one more slide if you don't mind.
Sorry about that.
So those are the things those questions have come up a lot because of the pandemic and the need to get things done, and really trying to see, do we have to do bidding or not because of those different processes. The other one I like to talk about is the use of consortiums or cooperative bidding in procurement. That's a hot topic now because, again, how can we get things and how can we purchase things without having to go through the bidding process? Because during the pandemic, it was obviously a process that was difficult to manage at times, especially at the very beginning. So you can use cooperative and consortiums to purchase supplies, materials, and equipment under 1274, to where somebody else did all the bidding, and then you would just be able to piggyback onto that. It's cooperative bidding and consortium bidding for construction projects would be highly problematic due to the requirements under the school code of what you have to follow. So obtaining those supplies, materials, and equipment, you can do that, but you want to make sure that the processes that they followed as part of that cooperative and that bidding process were compliant with our legal requirements in Michigan, because a lot of these may be national cooperatives or regional cooperatives. You want to make sure that they were legally compliant with both the law, and if you have any specific board policy that requires how you have to do things, make sure you're following those. And then at the same time, 1274 still requires the board to approve the purchase before you do that. So you would also make sure you don't miss that step. Just don't go buy it and then not have the board approve, because 1274 is 2 steps. You have to competitively bid if it's over the statutory threshold, and then you have to have the board approve. The other 2 ones at the bottom here, the waiver of legal requirements is also a topic here, because of people were doing RFPs or using RFPs and procurement documents that had specific things, and then trying to waive those because of issues that popped up with the pandemic that we'll talk about here shortly. And we always like to highlight, if the law requires you to do something, you cannot waive that. However, if you have an RFP requirement that's something more stringent than the law, you've asked them to do something more than what the law requires you to do, you could waive that if you wanted to, provided that you don't go any lower than what the law requires. And that's something you could do, and making sure you understand the legal requirement versus a procedural requirement and being able to waive those. That's something that's come up a lot of questions because of the pandemic and the things the restraints that it's placed on us there. The other one is just always highlighting, especially now in January here, we're looking at moving towards a lot of design season, getting ready to bid things out, making sure when you're looking at construction projects, there is a monetary threshold when you're doing a construction project that exceeds $15,000. You still need to engage a licensed architect and engineer to design the plans and specifications for those. And so make sure you don't miss that step. And that step is irregardless of the statutory competitive bidding threshold, which is just over $25,000 for this current school year. So it's obviously it's $10,000 less, and we don't want to miss that and forget to have those architects and engineers involved when they need to be involved in construction projects. So moving over to our next topic here is we'll get into some specific ones dealing with school construction and procurement as they relate to the pandemic and issues that they can cause. So this one hasn't really been affected too much by the pandemic, but it is something that is a new requirement in section 1264 of the school code. And what it requires is, in addition to the normal design that needs to be done by your architect, going through the state because they have jurisdiction over all school construction projects, and going through that process where they have all the approvals, you are also now obligated, if you're going to do any construction of a new school building or a major renovation, you have to consult on the plans for the construction regarding school safety issues with the local law enforcement agency that's the first responder. So that is an additional step that you have to do as part of your design process. And so you want to make sure when you're working with your architects and construction professionals that you don't miss this step. A couple nuances. They do define school building. So it's obviously if it's for instruction or if it's a recreation or athletic structure is a school building. So obviously if it doesn't fit within those, if you're doing a building that's not going to be used for either of those, either now or in the future, you could do away with this. But the tricky thing is they do not define major nor consult. So what does it mean to be a major renovation? Is there a dollar threshold? Is there a square foot threshold? None of that's defined. So obviously working within reasonable judgment, if you're going to add a new wing to a school, that's probably going to be major. If you're just doing some minor renovations to a bathroom or something of that nature, probably not major. Furthermore, consulting, obviously that would mean definitely talking to them and listening to them. Does it mean that you have to implement all of their suggestions? No, but it's something that you want to be aware of. So as you deal moving forward to our next slide, as we deal with this, the one major thing at the bottom here is it affects scheduling. And obviously, if you have multiple jurisdictions in your school, you would have to go to each of those. But it's dealing with how do we deal with section 1263 that I alluded to previously of the state has sole and exclusive jurisdiction over the review and approval of all of our plans, and how does section 1264 potentially affect them? Discussing with the local municipality, the first responder is key on safety issues. And then if they have any reasonable suggestions that you could implement, obviously you could suggest those, but obviously the state has ultimate authority over your plans. So that's where we have to obviously yield to them. So that's where just making sure you're aware of these as we're dealing with our design, getting a design in bidding season. So now if we switch over to a couple issues that have really been key on the next slide with respect to the pandemic, we have gotten a lot of issues of electronic bid submissions and how can we facilitate that, because currently not allowing to have public meetings over a certain, either all or not, can't have more than a certain number of people. Those are always issues. And so having electronic bid submissions in this, the pandemic era, is that allowed? And so obviously when you look at these is if we have competitive sealed bid requirements under 1264, how can we deal with those? Do we have processes that are different between our supplies, materials, and equipment under 1274 versus 1267? How can we deal with making sure everybody's able to participate and we're not leaving out bidders because of this electronic bid requirement? And how do we open bids? So those are all the big questions that we deal with. So at the end of the day, we believe that you can have electronic bid submission, provided that you work through these issues and you ensure that what the process or the platform that you're using satisfies these requirements. So having that sealed requirement, which is only a statutory requirement for construction bids, there are platforms that it's like a lockbox where the bidder submits its bid electronically and the school district is not able to access those until a certain time and date, which you would set at the beginning to open them up, whether it's the school district itself or your construction professional architect, using those electronic platforms that they have out there that would accept the electronic bid. And if you use that and ensure that you can't open them or see them and they remain electronically sealed, for lack of a better term, until the deadline, you can move forward with that. Just having them send it in via email where you could open it and access it isn't going to meet that sealed bid requirement. So you need to be aware of that, especially when you're dealing with construction process. When you have requirements to maintain all bids that are received on a construction or competitive bidding process under the rules and regulations for document retention for schools, so you need to be able to make sure you can save any of these electronic bids and you can retrieve them and all that, so you can meet all those requirements. And then when you're dealing with these issues, is how do you make sure everybody's aware of this process? You need to make sure that you clearly identify how they need to be submitted in the bidding documents and in the RFP itself. But under the construction, you have to have an advertisement you have to post on the state website and in the newspaper of general circulation. And you need to ensure that it's very clear in the advertisement as well that there is an electronic bid process or bid submission process that they have to follow and how they need to do that so people are aware of that. And then the last consideration is you should probably also be able to accept somebody to mail it in if you didn't want them to actually be on your property, have FedEx or some type of a drop off if they weren't able to do this, so you wouldn't foreclose anybody from participating. But at the bottom line, a lot of people ask about electronic bid submissions. Provided that they check off all these issues, I think you can do that. So moving to the next topic on the next slide is the complementary topic of can we have virtual or other type of bid openings or pre-bid meetings, other type of meetings that are associated with our competitive bidding processes. And again, we believe that you could do these provided that you meet and you check off various issues. So again, there is a difference in the process you have to undergo between 1267 and that very detailed statutory process for construction process or construction procurements as you compared to under 1274, there's a little bit more lax restrictions. So the key thing under virtual bid openings is under 1267, it requires you to open and read aloud all bids that are timely received prior to the deadline at this bid opening. It has to be a public, open to everybody. That it's not a public meeting as it relates to the Open Meetings Act, but it is a meeting that everybody needs to have an opportunity to attend. So how do we deal with that? Also, how do you make sure that everybody knows that it's a virtual platform? It'll be a virtual meeting where it's a bid opening. And how do they know how to get there? And how can you document that people attended so you know who's there? So using Zoom or any other type of a bid platform, you should be able to take attendance and mark people off as they make sure that they identify on their screen who they are. You can either take screenshots, write their names down, what have you. You can record those virtual bid openings so you have those to go back. But when you deal with the opening of the bid itself, you want to make sure that you can clearly show that when you do the virtual bid openings, that the bids weren't open prior to the deadline for due date. So maybe the deadline's 1 p.m. in the virtual bid opening. You're gonna open those and read them aloud. And you have to do that all on the virtual. You can't open them before and then say, well, we opened these all before, but now we're gonna read them out on Zoom. You need to be able to show that you're doing that all simultaneously, because it has to be all at one meeting. So make sure that the process you follow has the opening of the bids that are sealed, and you read them aloud for construction. You could do it a little bit differently for the 1274 supplies, material, and equipment, because there is no requirement there to have open and read aloud. But that's the biggest thing under the construction, is making sure that you're following that process. And the last thing we always like to highlight is to ensure people know how to attend. And we believe that the best way to do that is to include the address for the Zoom or other platform that you're going to use that everybody can attend, and put that in the advertisements. It's in the RFP itself, but also in the advertising that you publish in the state website, on the newspaper, so everybody knows how to attend. Why do we think that is? The other way you would do it is tell them to email you or contact you for that. And that's going to be an additional administrative step. Now you have to keep track of everybody emailing and making sure you're sending the right Zoom link. Then what about the public who may not otherwise be dealing, they just want to watch it, for example, watch the bid opening, make sure they have the ability, so maybe posting it on the school's website and saying, this is going to be a construction virtual bid opening, here's how we get to it. So multiple ways of getting to it, but making sure everybody's communicated how to do it, because it's a little bit different than just showing up in a live building and having that. So with that, we'll switch to the next slide. And the last thing is under dealing with emergencies and delays, which has been a big issue during the pandemic. And typically we had bid openings, and now our schools or our buildings, closed, we've had a couple where the people that needed to handle the bid opening were quarantining and they weren't able to come to the building that day. And so can we delay things? What if there's an emergency that needs to be done? We need to purchase something really quickly. A lot of it, maybe it's PPE and things of that nature. So looking at all these issues, there's a lot of these questions that come up because of the pandemic, and they're all very fact specific, but generally we'll talk about some of the emergencies and these delays. So generally with emergencies, the biggest question we get is, we need to buy a lot of it's been PPE that school districts need to acquire quickly in order to deal with the issues of getting kids back from remote learning or having staff and other things available. And how do they get that? Because everybody was trying to buy the same stuff. And if you didn't jump on it right away, you might not be able to get it. So a way to deal that is obviously looking at using cooperatives for that type of supplies, materials, and equipment. That's definitely a way to circumvent the competitive bidding process. But the other question is, well, as I mentioned earlier, 1274 requires school board approval of the purchase. But in the normal set of circumstances, the school district would carry out the process and say, we want to buy these, take a resolution to the board approves it, and they buy it. Well, because the boards were not meeting as quickly, or the board meeting already happened, and we needed to buy stuff today or tomorrow, could we look at having some type of a blanket approval for designated items and what levels? And I think we could look at doing a blanket approval by the board to have a resolution that allows the administration to buy, for example, personal protection equipment from certain vendors that they approve, whether it's through consortiums, up to a certain dollar level that the authority, so the school district can't just go out and buy $500,000 of face masks, but maybe they're able to buy 150,000 before they have to come back to the board for additional approval. And looking at those as ways to enable the school district to move nimbly through the market, because it was very difficult to find things at times. So those are things that you could do for emergency purchases. And that would be, there is no emergency exception to purchase equipment under 1274, but using cooperatives and these blanket approvals it would be a way to still have the flexibility and still comply with those requirements. And again, as we noted, 1267, there is no emergency for that unless it's emergency repair. And then you don't have to do the competitive bidding there. So we don't have to deal with, you can't deal with cooperatives like I mentioned before. So those are the types of issues and the differences between the two. Delays are always another tricky question. They're always fact specific. We've had, like I mentioned, the building was closed because of a quarantine issue on the day that the construction bid that was out there for 2 weeks and followed all the laws. Now, what do we do? We had one where the three individuals that were needing to open the bids and handle the process all had to be in quarantine for just under the new restrictions, and they were dealing with that. So how do we deal with all these delays if they're caused by the districts, the vendors themselves, they cause the problem, or if there's an act of God, and those are all different. So if the district causes the delay, for example, you gave them the wrong address and everybody went to the wrong spot, and now the bid opening had to be someplace else. And that's one thing you could easily change that. Or if all the individuals were out in quarantine or out sick that day and you had to have it back it up a day, we could work through those issues to get through those. And you could move the dates, and we'll talk about that in a second. If the vendor causes the issue, the dog ate my homework, or I got stuffed in traffic, or the U.S. Postal Service didn't deliver I put it in the mail 4 days ago, and I didn't do overnight, private, FedEx, UPS, and I just, the process that I used didn't get me there in time. Well, that's their problem. And we can't, say, well, we'll let you, even though your bid was late. Typically the RFP will state the school district's not going to be responsible for delays. So those are treated differently. We can't just give one vendor or contractor the ability to have a late bid, because under the statute, especially the construction statutes, you can't accept late bids. So their issue, if they cause the delay, they're sort of out of line. And then acts of God, the power goes out, things of that nature. Those are things that we could deal with and address. So to deal with these, you could always include contingencies in the advertisement to make sure that you still abide by the statutory requirements of having to have advertisement posted on the state website for 2 weeks and posted, or at least in the newspaper of general circulation at least once. So you can do that, and if you put in there that if there is an issue, we could reserve the right to delay it. If it's our issue, you could put contingencies in those advertisements to give you the flexibility, because the question that we get a lot is, well, the construction manager or the construction professional that's helping us through this project, just as some of the vendors have said, we're not ready yet to put our bid in, can we just move it back? Well, under the statute, that's always problematic, because the advertisement has to state the date, time, and place where the bids will be open, and it has to be on the website for 2 weeks. And if you just unilaterally change that and move it back a day or so, that could run into some issues. So how you do that and how you document that can be a problem. It happens in the field a lot, but those are things you just want to make sure you're aware of, so you're not running afoul with the requirements of 1267. So obviously delays are something that have been caused by the pandemic. Working through them is typically that you can get through them, but since they're fact specific, you want to make sure you sort of dot all the I's and cross all the T's as you get there, so you can still have your bids opened on time and still be able to meet the board approval deadlines. And obviously in the construction, you don't want to get behind in the construction process, because it just sort of stacks up and makes everything even more. So with that, I think we've covered our topics. And I think at this point, we'll turn it over to Tom and we'll look for any questions.
Yeah, well, thank you. That was excellent. Nice, concise. I wish I had that when I started out being superintendent about 2 decades ago. That was very informative. But a couple of questions I do have. And one of them is, this is a common occurrence where, in our case, we passed a sinking fund back in August, and we're going to have 6 bathrooms remodeled or redone. Punitively, they would cost easily more than the standard bid threshold. But together, and that's the design is going to be pretty much together. They above that, obviously above, but individually, each one would be probably below $15,000. You really, in a situation like that, you really have to look at it as a more than $3,000 project, correct?
Yeah, I think a couple things there. It's a great question. I think you have two. Is one, since you hit that $15,000 mark, is do I need to have each of those designed, and the bathroom renovations, the specifications done by an architect or licensed engineer, because maybe they are below the 15,000. And the secondary component is, do I need to bid that out? Is this one big project that's well over the $25,000 for bidding, or can I look at each of these individually with respect to bidding? So I'll take those in that order, because I think that's how I see those. And so while each of the bathrooms themselves, typically we look at are all these bathrooms in one building, or is it one bathroom in each of 6 different buildings? So could you look at the projects, building wise? That's always one thing. But with that, bathrooms, that would be something you would want to make sure goes to the state for the approvals, and they're going to typically require those specifications to be done. So just because the state is going to require it based upon their processes, it sort of solves our first question, is you still should make sure the architect or licensed engineer is designing all the specifications, because the state's going to require that. And that sort of solves the question. But even at the end of the day, I would still think that you would want to look at those as like a bathroom renovation project, and ensure that that's done for safety purposes, and also this functionality to make sure, obviously the toilet's flush and the water runs correctly, and not having any the bathroom. Now, the one is also, and we've had this before, is another tricky one is, well, can we look at these individual projects, or do we need to look at these as one whole project? If you have a legitimate business purpose where it's, different buildings, and you're looking at them individually, and you're going to be doing them on different time frames, you could potentially make a business case that these are all separate projects. And you have to look at a lot of different things, but you could potentially make a business case if they're all separate. But generally speaking, you would look at those as one bathroom renovation project. And I think that you would want to put them all together, bid them out. But when you bid them out, do them at unit prices, and don't just ask for one quote for all 6 bathrooms. I would get each bathroom individually, which would give you the flexibility of proving them individually. And maybe, well, I'm only going to move forward with 3 now and 3 later, so on and so forth, because then that would allow you some flexibility to get things done. But I would, unless there is some extenuating circumstance that would be requiring you, or be the need to skip the competitive bidding or try to alleviate it, I would look at them as one big project and do them together.
Perfect. And what about the electronic and the mailed in bidding? Can you have like a hybrid and use both of those? I think you may have mentioned you could, but I want to make sure that we cleared that up. You can have both of those things at the same time.
Yes, you could always do a hybrid and say, we will accept electronic bids via this electronic bidding platform, and you can submit it this way. Or if you would still want to submit a hard copy, you have to submit it this way, and you could still do both. At the end of the day, it all loops back with making sure all of those remain sealed until the due date and time where they're going to be open and read aloud at that public meeting.
Perfect. And one of the things superintendents often hear from their board is, well, we want to have local contractors, we want to use local talent, which is understandable. Is it okay to give them personal invites to a construction project? If you don't do that for pretty much, well, you can't logistically do it for everybody. So is that okay to have personal invites, from the school, on school stationery, that kind of thing?
Yes, for sure. And I would go even a little further. Is I think you can always, although you have to, for construction, if we're focusing on construction, for example, where you have to post your advertisement on the state website for 2 weeks and put it in the newspaper for once in general circulation where the project will be had. Obviously, those are the public announcements that the statute contemplates, but nothing in the statute forbids you from alerting any type of contractor that a bid is available, and we're just trying to drum up bids. So I think if you know that there are, whether it's a local or a non-local contractor, because as we know, once bidding season starts, all the good contractors are pulled in 10 different directions, and every school or other project wants them to be bidding on it. And who the contractors are. So I think you could alert them via this. It's not, giving you wouldn't want to give them any. You would want to publish the advertisement publicly and not give them you want to give them an unfair advantage so they know beforehand. But once you make the advertisement, public and the projects out there, there's nothing that would forbid you from just, hey, XYZ contractor, I just wanted to make sure you were aware that we have a bid out there. If we'd love to have, you to participate in our process. And whether that's a local contractor or a regional contractor, doing that, as long as it's not giving anybody an unfair advantage, I don't see that there'd be a legal issue with that.
Okay. And you were talking a little bit about the late bids and, having those provisos in the actual construction bids. The other question would be, and I'm pretty sure I know the answer, but some other people may not, is the fact that if a late bid is strong and you see it and it's so much stronger than any of the other bids, you do have a right still to go ahead and drop all bids and rebid the project.
Yes, so in the construction realm, if you have, obviously you cannot accept a late bid. That's statutory, section 5 of 1267. You cannot accept a late bid. It's illegal. You have to reject it. You can't even, it's not even supposed to open. If you really want to follow the conservative letter of the law. However, at any time and for any reason, the school district has the right under subsection 6 to reject all bids and rebid the project in accordance with 1267. So we've come into a number of reasons why a district has looked to remove all bids and reject all of them, and then come back and rebid everything. If one of the bids is stronger, if you want that bid, obviously you're going to have to reject all and rebid everything because if they're late.
And when you have paper bids only, in a situation like that, what's the best way to legitimize and make sure that people know that it was on that date and time? I know, the old movies where when there's a kidnapping, you show the daily paper headline or whatever. That seems a little excessive, but is there a way that because we haven't really been under this where we pretty much forbid the public to come in under some circumstances, what would be the best way you would think to make sure that, there's that confidence that it was done on the proper day and time?
Is that where you were only having, there was no electronic way to attend the opening of the meeting or the bid opening? Or is it,
okay,
there be an electronic option available?
Okay. Yeah. And if nobody's there, then at least make sure you record it and like there's a date stamp on the recording. That would be sufficient.
Yeah, I think if you're going to record a bid opening that's live and in person, and you're not having a Zoom feature or other type of virtual bid opening that other people could attend, you could record it, stamp things with the dates. Obviously, if push came to shove, there could be affidavits and stuff of people on, this happened at this time. If it got into a legal proceeding, we could do that. But most of the districts, if they know there's going to be a challenge in potentially having a live in-person bid opening, they've looked to include an electronic virtual option from the beginning, and maybe telling people you can either come in person or it's electronic, and it just depends on where our, right now the Department of Health and Human Services and where those orders land. Right now it's a 25 is the limit. So as of today, it could change. And so that's where usually giving them an electronic option so they can attend, and then you just record that Zoom feature or whatever platform you're using.
Right. Not to get too far into the weeds, but there are times when, especially in small communities, where the internet may be down, and even for a day or so. But that shouldn't be too much of an issue. I guess the last thing I would ask is could you give us a quick, just a thumbnail on the really important, pertinent, big picture differences between bond proposals and how you can use those fundings? And if that changes any of what we talked about versus a sinking fund situation.
Okay, so a bond under like a regular school building and site bonds.
Mm-hmm.
And then as opposed to sinking, and so are you saying what projects can you use those funds for, or is that the question? So I'm understanding it?
And I think you look at some of the opinions that are out there, you can find that pretty easily. But I'm just thinking the bigger pictures about dedicated funds, and is there a little more, you have a little more latitude when it comes to sinking fund as far as stating exactly what you're going to, use those funds for, or no? In my understanding.
Okay, I think I know where we're going. I'll give an answer thumbnail, and then if it doesn't hit on your question, we can look at it. But generally, from the very high level, sinking funds are only allowed to be used for what the statutory requirements are. But there's also another caveat to that, is it's also what your sinking fund resolution and quote unquote ballot language is as well. So now I've seen a lot of questions coming forth on listservs of what can I use sinking funds for, and people have chimed in and said, well, we can use it for security. And that's true under the new legislation that was enacted a few years ago, where you can now, it's an expanded use of sinking fund dollars. But you also need to look at when your sinking fund was enacted. If your sinking fund was enacted before the change in the law, you still have to follow the old law and what your sinking fund resolution allows. So it might not be security. If you want security, you'd have to go back and switch. So just because the law changed didn't change your ballot, your voter approval. And that sort of is a nice segue. So you can use sinking funds for capital improvements. You just can't use it on equipment. And there's always like a really like a fine line, or a lot of questions that get into the gray area. And it's always a good thing to look at. The MSBO or the Treasury has a bunch of their Treasury letters that dealt with allowable and non-allowable sinking fund uses. MSBO maintains a nice library of those, and although they don't publish those letters anymore, you can't ask for opinions from Treasury anymore. You can still rely on old ones, and so utilizing those as to whether or not it's a permissible or not permissible sinking fund expenditure is still a basis that you can rely upon. So that's for sinking funds. And now if you go over into bonds, again, there's specific statutory requirements under the school code of what you can use bond proceeds for. But it also goes even further. Again, it's what the ballot's language says. So if your ballot language isn't drafted appropriately, and even though the statute may allow a certain expenditure to be permissible, if your ballot language doesn't include it, you're precluded from spending money on that. So they both go hand in hand. But the sinking funds, the one is I want to know for security, depending on what your ballot language, what your sinking fund was enabled for, is where you want to make sure you're aligning, and you just don't just use it for whatever you want, even though it's a 10-year-old sinking fund.
Perfect. That's exactly what I was looking for. Well, I appreciate it. That's fantastic answers. Thank you.
Does anyone from the audience have a question for Jeremy? If you do, if you could please unmute yourself. And while we're doing that, Jeremy, I did have a question for you regarding the cooperative or the consortium regarding professional services. Do you know if that exists? Because I did come across an RFP recently for a municipality that said that once you were hired by the municipality, that they would put you into one of these cooperatives.
Well, professional services in Michigan aren't required to be competitively bid, and that's sort of so. And those could be architects, construction managers, attorneys, CPAs. Any type of a service. The base under Michigan law isn't required to be competitively bid. Now there are some exceptions to that. If it's a food service. management company, like you bring in somebody to run your food service department, that's a federal requirement. You have to competitively bid that. Also, if you're using federal dollars to pay for the service, you may have to, depending on the amount of money that federal money that you're using, you may competitively bid. But if you're just general, and there's a couple other ones, if it's a service that's, a unionized service, there's some other things that you die. But if we're looking at professional services, like construction managers, owners, rep, those, we don't have to competitively bid those. Although a lot of school districts do look at doing that. So you could look at a consortium if you were looking for a competitive process. If that maybe was a board requirement to bid out services and you wanted to look at a consortium, come across that all pretty much that much at all, because professional services are so unique to the district. You want to really in the scalability of their services and cost structure would be so unique to what you're doing. Just going off a competitive process from a consortium that was a regional or national one, I don't know if it'd be a good fit, but you obviously could do it. You needed to have some type of a competitive process for your board to satisfy engaging in one professional over another. If there's no legal requirement to bid it out, I don't see what would stop you from doing it.
Okay. Well, thanks for answering that, because I know that that's come up over the past couple of years for me, and just understanding that is good. And that's what I always thought too, is that the services are usually so typically unique to a particular school district or a project that I don't know how you would actually be able to make sense of that.
Yeah,
So
and the other side is I don't know if the pricing that somebody was obtaining through the cooperative would be, specific to enough to what you want them to do or need that professional to do, that you'd actually know you'd be getting, the right price for, the right size fit. Obviously something to look at it as part of that discussionary purpose.
yeah, like you mentioned in your presentation, there's a lot of nuances to that one. So, well, it looks like we're getting right up against time here, and I don't hear any questions from the audience. I'm just going to jump back into the presentation. I just wanted to thank you, Jeremy, for providing us with that presentation and the insight as it relates to the pandemic and school law. So thank you for being on the town hall, and I just want to thank the audience for participating. We will have this in our next newsletter and links to this particular recording for everyone to be able to access. Our next meeting is on February the 17th at 1 o'clock. And then finally, I just wanted to share with the audience, if I can get it to work. Here we go. This is Jeremy's contact information, and we will post these slides on our website, and in the newsletter there will be a link. So if you wanted to potentially use this to share with you back with your school community, please feel free to do so. So thank you, everybody, and we'll see you in a month. Thanks again, Jeremy.
Thank you.
All right. Bye, everyone.